Now back to Inside Real Estate. Here's Mike the Realtor.
Yeah, we're doing, folks. We are back. Hey, don't forget the website, InsideRealEstateRadio.com. InsideRealEstateRadio.com is the website. Hey, it's time to talk with our resident expert of all things legal. We've got Perry Cockerell here. And, of course, he's also the author of A Private War, which is available on Amazon. Also, his website, PerryJCockerell.com, PerryJCockerell.com. So, Mr. Perry, how are we doing today? It's good to see you.
Nice to be back and see you and everyone else here.
Good to see you. And by the way, a big congratulations to you. You've got a little one in the house again.
Little baby girl.
Congratulations to you and Camille.
Congratulations.
Yeah, that's huge. So, what I know we're going to talk about, what are we talking about, Bill 1894?
We are. I want to bring this back because this issue is one I spoke with earlier. It's about the boundary disputes, the encroachments, the improvements. It's where someone buys a piece of property and then they find out that their boundary is incorrect, that actually somebody's put an improvement on it. They moved the boundary line. They put an encroachment on it. Particularly where it comes up is kind of like AT&T or other entities. They might put underground cables. They might put a utility pole, or your neighbor might build a wall, or your neighbor might move the fence over a little bit because they think they own that land. That is a real serious problem that has been going on for a long time.
Sure.
And it's being litigated all across the United States. And the legislature has finally decided to do something about this. But just to give you a little recap, there's just two cases that are very contrasting. One of them is out of Fort Worth, but it was a landlord-tenant relationship. The lease is executed in 1994. In 2006, the tenant moves the boundary line and subleases out about 400 square feet of land to another communications entity, and they began making money off this little sublease, which is 1/3 the size of the entire lease, but more valuable than the entire lease. Landlord doesn't know this. The landlord signs an amendment in 2007 and doesn't realize the boundary line has been moved. And so when he comes to sell the adjoining land which he owns in 2013, he can't because there's an encroachment on the adjoining land, and he figures this out. So he files suit to remove his own tenant, which is really a subtenant, from this adjoining land and declare the boundary line. Now, what happened in this suit is the court said, well, you can't do that. That boundary line, those improvements were put there in 2006, and you didn't file suit to 2013. Your suit is barred 2 years after that occurred. You should have known. You're the owner. You should know what's going on in your property, essentially.
Right.
That's the first case. And the second case comes out of Corpus Christi, and that involved, adjoining landowners. One of them had a right to go over the other party's land to get to their land. Well, the one landowner just didn't like that, so they just built a wall to stop that. They don't want their next door neighbor driving over their land, even though they had an easement to do that.
Right.
4 years later.
And we see this a lot in rural areas. We see it a lot where the road is on one homeowner, landowner's property, and there's other homes are accessible off of that road. We see that a lot. And if that homeowner that actually owns the roadway becomes a problem, it can become a problem. You can't get to your house.
It's a problem that could potentially involve every piece of property that's purchased.
Yeah.
The boundary line might not be right. Somebody has a concrete sidewalk there. They might be sharing something on an adjoining land that might involve a party wall or something. It is not a good idea to not put your property, lines exactly on the lines. Make sure your fences and you have good neighbors. Well, in the other suit, they filed suit 4 years later, and the court barred the suit and said, well, no, 2 years. Well, they take it up on appeal, and they said, no, wait a minute. That's not correct. Texas has a concept of adverse possession, 3 years, 5 years, 10 years. You cannot bar this suit. What's barred after 2 years is the money damages for possessing that property. But what is not barred is your ability to tell them to get their property off the land. Now, this is what's going on even in several states and even in Texas, is that this concept of possessing the land is getting confused with this 2-year statute of limitation designed to limit the money damages that you can recover. That's what the legislature's trying to do.
Right.
But they're not saying now we have a 2-year adverse possession statute, which is effectively what is going on. It's going on because of the fact that there's some confusion over what is permanent damage and what is temporary damages. And the Supreme Court has defined that permanent and temporary. But though that definition is intended to be in areas, let's say where you have a chemical spill, or let's say where something is running on somebody else's land, or you've done something regularly, it might be permanent, and you might be able to fix it, but it's going to happen again in the future. That's what permanent. But this concept of permanent is being applied to improvements, encroachments, and boundary disputes. That's not what the statute, in my opinion, was intended to do at all.
Right.
And so by default, what's happening is let's say someone can come in and put a utility pole, underground cable. They can move a boundary line, even a cyclone fence, as in this case, and say, oh, Judge, this is permanent. Well, it's not permanent. Under this one case, it's a lease. It's got to come off at the end of the lease.
Right.
But you're telling the court it's permanent. They're successfully winning. They're winning by preventing the property owner's suit by saying it's barred by 2 years. But they're not winning because they're proving a right to be on the property, either under a document or they have established a right to be there by adverse possession under the 3, 5, and 10. So this one case is actually went all the way up to the Supreme Court. The Supreme Court would not hear it. It's actually went up now it's in the U.S. Supreme Court, and it challenges the constitutionality of this 2-year statute by saying that it conflicts with the adverse possession process and it denies due process. Basically, these people are acquiring other people's land.
Right.
They're not paying. They're doing it after 2 years. It's circumventing the adverse possession process, and they're saying that it violates equal protection because now the naked trespasser can boot the owner off the property in 2 years, whereas under the adverse possession, the trespasser gets 3, 5, and 10. Those are different times. You should be treated equally because you're similarly situated in the same real estate. None of it makes sense. Well, anyway, I give credit to Senator Connie Burton out of Fort Worth, who filed Bill 1894. Hasn't been assigned to a committee yet, but will be soon. But what this bill is designed to do is clarify that in this area law and say that this 2-year statute of limitation is not designed to circumvent the adverse possession process. It only says the damages for 2 years are barred. You still have a right to remove somebody, to tell them to get their utility pole off, to move their cyclone fence, to move their casual fence, to move their encroachments.
Yeah,
get them off your property.
Absolutely. I mean, slowly what's kind of been happening is the owner's rights have been eroding due to some of these precedents that have been set with some of these other cases, with this. And it's not what it's designed for.
It's exactly right. And it's occurring on a nationwide basis. Yeah. And this petition just argues that this is just another little erosion of your rights of small or large pieces of adjoining property. And it's really just overlooked.
Yeah,
and this is about encroachment on your property. What happens to the property owner when they make a mistake and reduce their property or their property line and they move their fence in or something like that? Is that affected by this, or is it strictly encroachment by others outside of your property?
Well, this statute will allow them to, it won't prevent them from being able to go back and get their property. The other side might say, well, too bad. We've had it here and your suit's barred by 2 years. That's not, they'd still have to establish 3, 5, and 10, which is what the legislature has. Everybody's known this for many years. 3, 5, and 10 is not used anymore because you can effectively boot somebody off after 2 under this other statute, that this statute was not intended for that purpose.
Not for that purpose at all.
And
they definitely need to clear all of this up because we need to protect the property owners. But until that happens, if you're a property owner, particularly if you've got hundreds of acres and you're not out there looking at it, and maybe you're leasing it, maybe it's a deer lease or it could be any of that type of thing. where you're not going to the property regularly, you don't know what's going on. Something like this could happen to you where you lose, some of your rights.
That's exactly right. Sometimes the property is under management by, like, for example, in this one in Fort Worth was under property management. It was a property manager that moved the fence line, and now say it's permanent damage. You can't sue me.
Unbelievable.
It's you have to be careful who manages the property. I guess, do I have more time? Or just let me know.
We are
I'm
running.
Done.
Yeah, we're running.
I'm
now.
good.
Okay. Very good. Well, good
you.
stuff. Well, as this progresses and hopefully they start to, this definitely needs to be handled. And it's so important that you're bringing it to us because, if you're a major property owner, and obviously we're talking about, acreage in most cases with these types of cases where the damages are and where a leasee can, somehow get additional rights, through some of these statutes. You got to be careful out there. And that's, we're talking to you guys. So, folks, we're going to take a short break. Then we're going to come on back.